My name is David Hodson. I'm a solicitor, mediator, arbitrator, and I'm a partner in the International Family Law Group in Covent Garden in London. I'm editor and one of the primary authors of the International Family Law Practice produced by Jordans, and we have just published the 4th edition in late spring 2015, and now we have produced the digital online version. One of the issues that arises when an international client comes to see us is what is the status of their relationship? So one of the most important chapters in the book is recognition of foreign marriages and recognition of foreign divorces. At the beginning of a case, a client with international aspects can present a whole series of quite complicated facts. Where does one start? In my experience, the best place to start is to break down what is the status of the relationship and therefore what legislation, what remedies, what claims are available. So why is recognition of a foreign marriage important? Well, if it's recognised, then there's the opportunity of divorce claims. If it's not recognised, then a person is a cohabitant with minimal nominal claims. It affects tax, immigration, nationality, welfare benefits, a number of these issues. How does England look at recognition of a foreign marriage? It finds just two elements, and if they're both present, it will be recognised. The first element is what is known as formalities. If a marriage abroad is good, in accordance with the formalities of the law where it occurs, it will be recognised by England. Doesn't matter that England wouldn't allow those formalities, would want more or less. If it's good by the formalities of the law where it occurred, that is fine. The second one is capacity. If the parties had the capacity to get married, then again it will be recognised. Capacity is based on their domicile before they got married. Capacity is matters of age, gender, were they previously married, blood relationship, a number of these sorts of issues. Obviously the matter of consent comes into the question of capacity. And so one looks at, was there formalities, form, was there capacity, and if so, England will recognise. We're fairly generous in recognising as much as possible. We recognise many polygamous marriages, not if they occurred in England, but certainly if they occurred abroad and there was the jurisdictional element to it. The next element is the couple have been divorced abroad. The client comes in wearing a divorce order of some form. Is recognition of any relevance there? Well, most definitely it is. England may not recognise that divorce, in which case the person could bring divorce claims here. If England does recognise, they may have to rely on Part 3 of the 1984 Act to bring financial claims after a foreign divorce. And again, it has implications for tax, welfare benefits, nationality, etc. In this respect, recognition of a foreign divorce really depends where it occurred. If it occurred according to a civil court anywhere in the British Isles, it will be recognised. If it occurred from a civil court, a family court, anywhere in the European Union, it will almost always be recognised. Just very rare exceptions under public policy will it not be recognised. It's divorces outside the European Union that are the more problematical areas. And they come into two categories: proceedings divorces and non-proceedings divorces. Proceedings divorces are, at one category, very straightforward. Any civil court, any family court of any country around the world, we are likely to recognise. It will need the respondent to have had a chance to take part, to have been served with a regularity, a formality. It must be proper due process and all that sort of thing. But this category of proceedings divorces, the first category, also includes something known as extrajudicial divorces. And this can include a divorce outside the civil courts, but with some state organisation involved, some registration process involved, registered at the town hall or with a central government in some way. And it's necessary to find out what it is. It doesn't mean that if it hasn't gone through a civil court, it won't be recognised. It may be recognised as what is known as proceedings divorces. And then there is the second category known as non-proceedings divorces. And these are much looser, more informal. They won't have gone through a civil court. They probably won't have gone through a registration process in the country where it occurred. They will invariably be some sort of religious divorce. Again, England has a fairly liberal policy. I've seen over the years becoming more and more liberal and recognising more of them. But take care with those. You'll need to take advice locally as to what sort of procedure was involved. So in this way one can find out, was that divorce abroad recognised, and what sort of claims will there be here. And then, almost as a postscript, there are the so-called religious divorces actually occurring in this country, and we've got to be culturally sensitive. There could be a Jewish get, an Islamic talaq. They may actually have to be tied in with the civil divorce proceedings in the family court. One may have to start, then there may be the religious one, and then the English decree absolute may follow. We need to be culturally sensitive to this. And then the last issue, which is in some ways related to this, is the problem in the Islamic community where there are a considerable number of Islamic ceremonies occurring in this country frequently where they are not registered marriages. The couple are not married according to English civil law. And again, practitioners must be conscious of this, must be aware of this. Somebody comes in and says, yes, I'm married. One must always double check they were married in a way either that's recognised in English law or actually is, if it occurred in this country, according to the English law. And there are a number of so-called non-marriages that actually the couple believe they are actually married. So a great care is needed. But at the outset of any case with an international element, what is the status of the parties? Marriage, divorce, is it recognised in England or Wales? And then one moves on to say what claims, what remedies can then be made.